Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And I know it has been a while, so hey y'all. Okay, hope everybody is doing well. And so you guys, I'm here with you today as a follow-up to the story involving R. Kelly, blogger Tasha K, as well as a BOP or a former BOP officer who is referred to as Officer A, who stole Mr. Kelly's records when he was located in the MCC Chicago, I believe is where the records were taken from. But in any event, she accessed his records, shared them with Tasha K and probably some other people, and she ended up losing her job behind it. And I did a video earlier this year that really pissed you guys off, but it still remains true that it is going to be hard for Tasha K or for anything to happen to Officer A in this quest, but Jennifer Bonjean has decided to file a lawsuit against them, and so it is going to be interesting to watch, mainly because the outcome could set precedents as it comes to how prisoner records are handled and how information gets out. And if he were to win this case, he definitely could sue for a bunch of money. Not sure how much he would get back. Now, when I did that last video and you guys were so upset about it, I had started working on a follow-up video, but then it was just so time consuming because I had to read all these court cases, and like some of these cases were hundreds of pages long, and I just did not have the time and the energy to put into it. But to sum it up, like you guys were saying, that it was criminal for Officer A to access those records. And even if she was charged with accessing the records and taken to trial, I think the maximum is it's a misdemeanor. It's not like a felony charge. So at most she would have gotten like a 6-month suspended sentence with a small fine. And then as for Tasha K, I still stand on the fact that Tasha K did not break any laws when she received the records from the BOP officer, because there was no proof that Tasha K had reached out to this lady and asked this lady to access these records. From all indications and from what we've been able to see from the court documents, the officer accessed the records on her own, as well as like 100 and some odd other number. It was either 167 or 67 other employees. I mean, like everybody was accessing his records, trying to see who he was emailing and all of that type of stuff. Now, Tasha K, according to court cases that I have read that was similar to this one, where a journalist received information from someone working inside a federal role, whether it was the prisons or not, but some kind of federal role where they had access to people's information and gave that information to a journalist. The journalist was not held liable because they did nothing illegal. It's not illegal for them to take the information. They just can't pay for the information or send somebody in to steal the information. And I know a lot of people say, well, Tasha K is not a journalist, but according to Supreme Court rulings that have taken place, YouTubers and bloggers, people who have like written blogs, like your Sandra Rose, the Shade Room, that type of thing, they are protected under the same laws that protect reporters that work for news stations and newspapers. But once again, it is going to be very interesting to see how this plays out, because it could very well end up in the Supreme Court and set precedents as far as this is concerned. So the news that's coming out today is that Jennifer Bonjean, she made good and said that she was going to sue, and she has indeed filed a lawsuit. So first I am going to read an article from the Chicago Sun-Times, and then I am going to read the actual lawsuit to you guys. So the Chicago Sun-Times says former R&B star R. Kelly, who is serving a decades-long prison sentence for crimes, has sued the federal government over the leak of Kelly's private information while he was locked up in Chicago's federal jail. Kelly's attorney, Jennifer Bonjean, filed the lawsuit Monday in Chicago federal court. It alleges that 60, okay, so it was 60, I said 167, but Jennifer Bonjean says it was 60, so we're going to go with her. 60 Bureau of Prisons officers improperly accessed Kelly's records between July 2019 and January 2020. And so it's important to note that inmates only have a certain level of expectation for privacy. We know that their mail, their emails, their phone calls, all of that is monitored. So there are BOP officers who do have legal access to this information. They just can't be given the information away. And so some of these 60 Bureau of Prisons officers may have been acting in the capacity of their duties. Officer A, however, was not, okay, because she had nothing to do with the R. Kelly case or the MCC. I believe she worked somewhere totally different. So the article goes on to say a federal investigation into the leak went public in September of 2021. It did not lead to criminal charges, and criminal's lawsuit alleges that the conduct continued nearly a year after, when an officer improperly accessed Kelly's records in August of 2022 and leaked information to the Washington Post. Oh, so they just weren't going to stop. So that's the same month that Kelly went to trial last year in Chicago. Kelly's lawsuit targets unidentified officers with the Bureau of Prisons, as well as the blogger known as Tasha K. Kelly is being held at a medium security prison in Butner, North Carolina. Records show he is serving a 30-year prison sentence for a 2021 racketeering conviction in Brooklyn federal court. Despite the conviction, he also went to trial last year in Chicago, where a jury found him guilty of producing CP and enticing individuals into criminal activity. U.S. District Judge Larry Lennenweber then gave him a sentence that effectively added just 1 year to Kelly's earlier prison sentence. So Kelly is not due to leave federal custody until December 2045. Still, Bonjean wrote in her complaint that the Bureau of Prisons had a duty to protect Kelly and his private and sensitive information, and instead she alleged that it allowed countless BOP officers to access Kelly's confidential information without any legal bias or basis to do so. One unknown officer unlawfully downloaded that information and sold it to Tasha K., a YouTube blogger with more than 1 million subscribers, according to the lawsuit. Now, she's saying that she sold it to Tasha K., but that investigation that they did came back and said that there was no money exchanged and that Tasha K. did not ask this lady to do this, but instead this lady reached out to, I'm saying it's a lady, whoever the BOP officer is, reached out to Tasha K. and offered her this information. So perhaps Bonjean has some more information or some evidence to the contrary that shows that Tasha K. did receive payment for this information. So Bonjean wrote that, quote, there has been a cover-up of the rampant BOP misconduct that is ongoing, end quote, and that the leak created chaos in Kelly's personal life. So that was the end of that article. Let's see what you guys know. I hate TMZ with a passion, but let's go on over here and see what they have to say about this whole situation. Okay, and another situation. Let's see. So Kelly is taking Uncle Sam to court because he claims federal prison officials leaked a bunch of his private info to an internet blogger who aired a lot of his laundry. The incarcerated singer just filed a lawsuit against the U.S. government, a handful of Bureau of Prisons workers, and Tasha K., all of whom he claims were in cahoots to publicize the private matters while he was in custody out in Chicago during his case there. So Kelly points the finger at 3 unnamed BOP officers or officials at the prison he was being held at, alleging they accessed their internal system that documented what Kelly was doing within their walls, including email correspondence, private calls, visitor logs, etc. And you guys know they all Tasha K also shared who was sending him money via his commissary. So Kelly and his lawyer, Jennifer Bonjean, believe the officials struck an agreement with Tasha K to supply her with Kelly's personal info, which he suspects might have been done for cash. Tasha has already addressed these claims, which Kelly publicly made well before the suit, and denied being mixed up in any illegal activity. Kelly claims the info allowed Tasha, who has a big YouTube following, to publish unflattering pieces about him, which he says has hurt his reputation, invaded his privacy, and caused him undue emotional distress. Kelly says the U.S. government was negligent in allowing its prison personnel to allegedly access and share this info, and now he's asking for major damages. By the way, the claims Kelly is making here date back to 2019 or so. Since being convicted in his Chicago case, he has been moved to a federal facility in North Carolina, where he's serving his sentence. Also, Tasha K is the same woman Cardi B successfully sued for defamation. Okay, so now I am going to read to you guys the actual documents that the actual lawsuit that Jennifer Bonjean filed. Okay, let's start with the complaint. Plaintiff Robert S. Kelly. Oh, let me go back up here. It says Robert S. Kelly is the plaintiff, and it's versus the United States of America, unknown BOP officer A, unknown John and Jane Doe BOP officers, Latasha Kebe, also known as Tasha K. So plaintiff Robert S. Kelly, by his undersigned attorney for his complaint against the United States of America, unknown BOP officer A, defendant BOP officer A, unknown John and Jane Doe BOP officers, collectively BOP defendants, and Latasha Kebe, also known as Tasha K. So the introduction. 1. The plaintiff sues the United States of America, unknown BOP officer, also known as Officer A, unknown John and Jane Doe BOP officers, and Latasha Kebe for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act, FTCA. Plaintiff also brings suit against the defendant, BOP Officer A, for violation of the Computer Fraud and Abuse Act, CFAA. So plaintiff is a high-profile prisoner of the Bureau of Prisons. He is a Grammy Award-winning recording artist and a nationally recognized celebrity. As for all prisoners, but particularly Because of plaintiff status, the United States of America through the BOP had a duty to protect plaintiff and his private and sensitive information to ensure that its employees did not exploit plaintiff for financial gain or for any other reason. The defendant, United States of America, breached its duty of care to the plaintiff when it allowed countless BOP officers to access plaintiff's confidential information without any legal basis to do so. The defendant, United States of America, knew that defendant BOP, Officer A, and other defendant John and Jane Doe BOP officers routinely access plaintiff's private information from his system and divulge private information to third parties for monetary gain, clout, or simple harassment. Because of the United States of America's breach, at least 60 BOP officers made unauthorized access to plaintiff's sensitive, confidential, and private information maintained by the BOP on its electronic system known as TrueView. Some of those BOP officers either shared and or sold that information to third parties, including members of the media and witnesses in plaintiff's criminal prosecution. Defendant unknown BOP Officer A accessed plaintiff's private BOP records through the TrueView system, including email communications, visiting lists, inmate trust account information, and recorded phone calls with third parties and plaintiff's attorneys without authority to do so. The information was private and concerned personal matters. It was not public information. After unlawfully accessing the foregoing protected information, defendant BOP Officer A unlawfully downloaded the information and sold said information to defendant Kibi, a popular YouTube blogger with over 1 million subscribers who published the private information publicly without identifying how she received it. Defendant Kibi rallied her massive following to harass the plaintiff with the use of the stolen information and created chaos in plaintiff's personal life, even using the information to influence witnesses in plaintiff's Eastern District of New York criminal prosecution. On information and belief, the stolen information was shared with and used by prosecutors from United States Attorney's Office as a tool to influence witnesses against the plaintiff. The sale of the information yielded profits that neither defendant BOP Officer A nor defendant Kibi were entitled to and which belonged to the plaintiff, if anyone. The Department of Justice Office of the Inspector General investigation initiated a secret investigation into the unauthorized access of plaintiff's sensitive information. The department did not inform plaintiff of the investigation and never has. Plaintiff later learned that the investigation resulted in the issuance of a search warrant for a BOP computer used by defendant BOP Officer A and forensic analysis of the computer. According to an affidavit of Special Agent Matt Lux of the Department of Justice, later obtained by plaintiff's attorney, probable cause existed to believe that defendant BOP Officer A Officer A committed a criminal violation of 18 U.S.C. Section 1030A to B, that is, unauthorized access of a computer to obtain information from the Federal Bureau of Prisons. No charges were brought against defendant BOP Officer A, and the government has refused to reveal any details about the investigation, including the identity of Officer A. In short, there has been a cover-up of the rampant BOP misconduct that is ongoing. Okay, so let's stick a pin in here because I believe I mentioned, if not in the video that I did where I said I don't think anything is going to come of this, I said it in another video that The only chance that Jennifer Bonjean had of getting this information and finding out who all was involved was if she filed a lawsuit. And so here she is filing the lawsuit to hopefully get this information. But as I stated in the research that I was doing, the research was just so overwhelming, guys, that I just couldn't even put it all together to create a video to bring to you all, because there have been so many lawsuits against the BOP, okay, for revealing people's information or letting their employees access people's information, but nothing really ever came of any of it. And in the cases where it was merited, you know, I think these cases ended up going to the Supreme Court, or either the award was nothing, you know, it wasn't even worth the time. So we continue on. We're at point 9. It says, even after this so-called investigation, unlawful access of plaintiff's True View records continued, even after being put on notice of repeated violations of the CFAA by BOP employees. The United States failed to protect plaintiff and breached its duty to protect his private and sensitive information. 10. For example, defendant unknown John or Jane Doe BOP officer made an unauthorized access to plaintiff's True View records and obtained information about plaintiff's trust account funds in August of 2022. That unknown defendant BOP officer divulged the information to a journalist for the Washington Post who published the personal information. The publication not only placed plaintiff in a false light, falsely suggested he was concealing his resources. The monies were actually generous gifts from his loyal fan base, but resulted in the DOJ confiscating nearly all of plaintiff's monies held in his prison trust account, over $25,000. Plaintiff was forced to pay for legal services to litigate the unjustified taking of the money, an issue that is now pending before the Second Circuit of Appeals. Plaintiff maintains that the DOJ had no authority to confiscate the funds, which would have not occurred in any event if the information was not leaked to the public by a defendant unknown John or Jane Doe BOP officer. 11. Defendant BOP officers committed the torts of invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton misconduct. The defendant BOP officers, including defendant BOP officer A, also committed violations of the Computer Fraud and Abuse Act. Plaintiff suffered a multitude of loss and damages as a result of the defendant United States of America's negligence and the torts committed by defendant BOP officer A and other unknown John and Jane Doe BOP officers, including but not limited to legal fees and emotional and psychological distress. 13. Separately, losses in excess of $5,000 accrued as a result of the CFA violation committed by defendant BOP officer A. The misconduct resulted in an internal investigation by the BOP, an investigation by the DOJ, OIG, and both the seizure and examination of a BOP computer hard drive. So, jurisdiction and venue. This court has subject matter jurisdiction over the matter pursuant to 28 U.S.C. section 1331, in that this action arises under the laws of the United States of America and is premised on the acts and omission of the defendants acting under color of federal law. The court further has subject matter jurisdiction pursuant to 18 U.S.C. section 1030G, which permits an individual who suffers damage by reason of a violation of the CFAA to bring a private cause of action. The action is timely filed where it is brought within 2 years of the discovery of the damage. So let's look up CFAA and see what they have to say about it. Okay, Computer Fraud and Abuse Act. The Computer Fraud and Abuse Act was enacted in 1986 as an amendment to the first federal computer fraud law to address hacking. 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 Y'all know what I'm saying. Okay, so over the years, it has been amended several times, most recently in 2008, to cover a broad range of conduct far beyond its original intent. The CFAA prohibits intentionally accessing computer without authorization or in excess of authorization, but fails to define what without authorization means. With harsh penalty schemes and malleable provisions, it has become a tool ripe for abuse and use against nearly every aspect of computer activity. Okay, so like with the other laws that will ultimately impact this case, the definitions are really broad, and that is how the government seems to be getting away with some of the things that are taking place, because it's just not written, in clear, bold print what is and what isn't allowed. So let's see. So 16. This court further has subject matter jurisdiction over the matter pursuant to Title 28, United States Code, Section 1346B, where plaintiff sues the defendant, the United States of America, for money damages for injury caused by the negligent and wrongful acts and employees of the government while acting within the course and scope of their office of employment under the circumstances where the defendant is a private person would be liable to the plaintiff. 17. Jurisdiction founded upon federal law is proper in that this action is premised on federal causes of action under the Federal Tort Claims pursuant to Title 28, United States Code, Section 2671. Number 18, pursuant to FTCA, plaintiff filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. Okay, so Jennifer, you got an extra zero in there, so that kind of, I don't know if that's supposed to be $10 million or more, or you just put an extra zero, which would make it $1 million or more. So 19, the letter dated June 15, 2023, plaintiff's claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the plaintiff's counsel. And then they have the claim number. 20, this action is timely pursuant to Title 28, United States Code, Section 2401B, in that it was presented to appropriate federal agency within 2 years of accrual, and this action was filed within 6 months of the receipt of the certified letter sent by the federal agency denying the claim. 21, this court also enjoys supplemental jurisdiction, if necessary, under Title 28, United States Code, Section 1367, in connection with claims against defendant Kebe, who, if not acting as a contractor for the federal government, is liable for claims that are so related to the claims in the action within such original jurisdiction that they form part of the same case or controversy. 22. Venue is proper in this district pursuant to Title 28, United States Code, Sections 1391B and 1391C, as defendants do business in this judicial district and a substantial part of the events giving rise to the claim occurred in the judicial district. So parties. 23. Plaintiff Robert S. Kelly is a 56-year-old Chicago native. He is indisputably the king of R&B. He is currently an inmate incarcerated in the Butner Federal Correctional Center in Butner, North Carolina. At times relevant to this complaint, plaintiff was an inmate at the Metropolitan Correctional Center in Chicago, Illinois. Defendant, United States of America, is subject to suit for injury caused by the neglect and wrongful acts and omission of employees of the government while acting within the course and scope of their office and employment under the circumstances where the defendant, if a private person, would be liable to the plaintiff pursuant to the FTCA. At all times material to this action, unknown BOP officer known as Officer A was a federal BOP disciplinary hearing officer and law enforcement official employed by the BOP with access to the BOP's TrueView system. Although plaintiff does not know the true identity of Officer A, the BOP does. She is the officer identified in the search warrant application and affidavit of Agent Matt Lux that was provided to plaintiff by the United States Attorney's Office in June 2022 during plaintiff's prosecution in the Northern District of Illinois. At all times material to this action, unknown John and Jane Doe BOP officers were BOP officers assigned to the Chicago MCC and perhaps other BOP institutions with access to the BOP's TrueView system. Although plaintiff does not know the identities of the 60 different BOP officers who made unauthorized access to this confidential information, the BOP does. Plaintiff sues each and every BOP officer who accessed his confidential information without authority and whose identities are available from the BOP. Okay, so this once again confirms that this is a fishing expedition and not a serious lawsuit, because she doesn't even know who she's suing. And the only way she can get the names, I guess, is to file this lawsuit, and then somehow a judge forces the BOP to turn over the information that she's looking for. So 27. At all times material to this action, Latasha Kebe is a resident of Lawrenceville, Georgia. Kebe is a popular YouTube host with a YouTube channel called Unwind with Tasha K. She broadcasts content to 1.3 million subscribers across the country, including in Chicago, Illinois. So then we move on to the facts of the case. So number 28. Plaintiff was arrested in the United States District Court, Northern District of Illinois on July 11, 2019 in connection with the 13-count indictment. Shortly thereafter, plaintiff was separately indicted in the United States District Court of the Eastern District of New York in connection with RICO charges brought under case number 19 CR 286. 29. After his arrest, plaintiff was detained in the Metropolitan Correction Center, also known as MCC, for nearly 2 years until he was transferred to the Metropolitan Detention Center in Brooklyn, MDC, to face trial in the Eastern District of New York case in and around June 21st, 2021. During this period of time, plaintiff was a pretrial detainee. While detained in the MCC in and around January 2020, plaintiff's longtime girlfriend, Jane Doe, who we know as Ariel, began behaving in a hostile and accusatory fashion toward the plaintiff without explanation. Ariel was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. These arguments related to money issues, romantic issues, and other highly personal issues. Plaintiff later learned that in and around that time, Azriel abruptly began cooperating with the government, which led to her becoming the government's star witness against him in the Eastern District of New York prosecution. In and around that time, defendant Kibi, a popular YouTube blogger, began publishing information to her 1.1 million subscribers and other viewers, private information about the plaintiff to which she should not have had access. Defendant Kibi did not reveal how she received said confidential information. Just by way of example, on November 7, 2019, defendant Kibi posted a video on YouTube titled, "R. Kelly Can't Control His Girlfriends While Behind Bars." Kibi told her viewers that the information came from a quote-unquote phone tap somewhere. Kibi disclosed information that appeared to come from plaintiff's prison calls with Azriel Clary and his girlfriend Jocelyn Savage. I'm sorry, she got JS here, but we know who we're talking about. So Kibi appeared to disclose private and personal information about plaintiff's romantic relationships. Defendant Kibi proceeded to divulge to her YouTube viewers the contents of plaintiff's prison phone calls with girlfriend and others, email communication about his private life and legal issues with numerous people, visitor logs, and trust account information on numerous other occasions, again without disclosing from where she received the information or how she received the information. Plaintiff was incarcerated and had no ability to watch Kibi's YouTube channel or learn the specific information that was being said by defendant Kibi. At one point, plaintiff visited with Azriel Clary and was shocked and confused when she accused him of making certain statements concerning his personal life that were only shared with plaintiff's lawyer at the time. Azriel Clary refused to divulge how she received the information but claimed that she was privy to plaintiff's conversations with his attorneys. Plaintiff had no idea how certain private information was making its way into the public domain. In early 2020, the BOP went on a complete lockdown as a result of the pandemic for a year. Attorney visits were conducted entirely by phone, and eventually Zoom visits and face-to-face visits did not resume until late 2022. It is unclear how many of plaintiff's attorney-client communications were shared with third parties by defendant BOP Officer A, or why those communications were being recorded at all. So let's stick a pin there, because word on the street is those lawyer-related calls that Azriel got access to were not official calls. They were actually private calls, which weren't so private because somebody's listening. But those calls allegedly were between him and Nicole Becker. And because they were not related to his case, but personal communication between the two of them, that was very, very personal, that's how the calls got recorded and leaked to Azriel. Or leaked to Tasha K, who then gave them to Azriel. So that's going to be something interesting to follow also, to find out if the truth comes out about those calls between him and Nicole. So let's see. In June 2021, plaintiff was transferred to the MDC in Brooklyn, New York to stand trial in his RICO prosecution. His federal RICO trial commenced on August 9, 2021. A jury returned a verdict against him on September 27, 2021. Plaintiff's current counsel filed an appearance in the Eastern District of New York case in October 21 for the purpose of handling post-trial motions and the eventual appeal. Her role expanded after plaintiff's original trial lawyers withdrew from the Eastern District of New York case by January 2022. Undersigned counsel filed an appearance in the Northern District case on February 18, 2022, and with her legal team began preparing for plaintiff's Northern District trial scheduled to commence in August. After counsel's legal team received information about the unauthorized and illegal taking, selling of taking/selling of plaintiff's private information, counsel sought discovery from the government. On June 14, 2022, attorneys for the government produced to plaintiff's counsel an application and affidavit for a search warrant under the case caption in the matter of the search of the HP desktop computer bearing serial number 2UA8480J G51506. The materials did not include plaintiff's name or any BOP officer name. Neither plaintiff nor his counsel had access to the anonymously filed search warrant application and affidavit until it was produced by the government on June 14, 2022. The government refused to provide any additional information despite plaintiff's request. According to the materials produced in June 22, Special Agent of the Department of Justice of the Inspector General Matt Locks, Agent Locks is how he'll be referred to going forward, executed an affidavit in support of a search warrant for a computer located in the Northern District of Illinois related to a violation of Title 18 United States Code Section 1030A2B, that is, unauthorized access of a computer by obtaining information from the Federal Bureau of Prisons. Agent Locks averred that the OIG received information from the BOP that unknown BOP Officer A was suspected of accessing sensitive law enforcement information maintained on the BOP's electronic systems and providing that sensitive information to an individual who then released the information on social media platforms. Specifically, the warden of the MCC in Chicago reported an allegation of staff misconduct to BOP Office of Internal Affairs when MCC staff became aware that unknown BOP officers, including defendant BOP Officer A, has stolen plaintiff's sensitive information from the BOP's electronic system, known as the TrueView system, without authority to do so. So the BOP's TrueView system is an application that contains information on inmates, including inmate emails, inmate telephone calls, inmate visitation lists, and inmate funds. The TrueView system contains information from various other applications and systems existing in BOP's network infrastructure. The information available on TrueView include information from BOP application TruePhone, the inmate telephone system, which houses recordings of inmate telephone calls. Agent Lux's investigation showed that unknown BOP Officer A had not only made unauthorized access to plaintiff's TrueView records, but stole information from the records, downloaded information, and then divulged that information to YouTube blogger Defendant Kiwi. Defendant Kiwi then revealed that stolen and sensitive information to the general public and to specific third parties, including Ariel. On information and belief, Defendant Kiwi and other unknown individuals bought the information from defendant unknown BOP Officer A. The information constituted inter alia private conversations between the plaintiff and Ariel and his girlfriend Jocelyn Savage. The communications related to personal and private relationship matters, financial issues, and even attorney-client matters. Although plaintiff did not know at the time how Ariel obtained the information, when plaintiff had the opportunity to learn of the contents of Agent Lux's affidavit, he deduced that the information had been stolen by the unknown defendant BOP officer, sold to Defendant Kiwi, and then exploited for profit when Defendant Kiwi divulged it to the public and to other third parties, including Ariel. Now, in writing this, I just want to put a pin here. In reading this, it seems like they're trying to say that Officer A was actually in Chicago at the MCC. Are y'all hearing it that way? But I really believe, without having the paperwork right here in front of me, but you guys can go back and look at my previous videos on this. I believe Officer A lived in Minnesota or somewhere. I don't think she was in Chicago. So we're on to point 49. It says defendant Kibi recently admitted on one of her broadcasts that she did obtain the information from defendant BOP Officer A and not only disseminated the information publicly, but provided additional information to Azriel Clary and others, including Azriel Clary's family members, for the purpose of interfering with plaintiff's criminal prosecutions. The release of this private information on the internet created a feeding frenzy about plaintiff's personal life, his relationship with Azriel Clary and Jocelyn Savage, and resulted in the termination of certain important relationships that plaintiff enjoyed with other individuals. The unauthorized release of the information led to a physical fight between Azriel Clary and Jocelyn Savage that made national news, the theft of thousands of dollars, and chaos and discord in plaintiff's life. Furthermore, because information about plaintiff's visiting lists and trust fund balances became public news, plaintiff was no longer able to enjoy certain important and supportive relationships with people. Defendant Kibi released the names of certain individuals who supported plaintiff, publicly shamed those people, calling them enablers, and interfered with those relationships. Understandably, plaintiff's associates did not wish to be harassed or have their employment put in jeopardy because of the illegal conduct of defendants POB Officer A and Kibi. Plaintiff suffered significant emotional distress as a result the release of his information and further worried about what other private information was in the hands of third parties. Both before and even after plaintiff learned about Agent Locke's affidavit, plaintiff spent sleepless nights distressed and confused how his private conversations had been leaked to the public and who was responsible for it. Importantly, plaintiff suffered emotional distress because he did not feel at liberty to freely speak with his attorneys. Plaintiff learned that his attorney-client communications were not only recorded, but information from those calls were released to Azriel Clary and presumably others. Plaintiff did not and still does not know the extent which his private information has been divulged publicly. Agent Lux's investigation revealed that from the period of July 15, 2019 through January 8, 2020, 60 different BOP officers had accessed plaintiff's TrueView records, including defendant unknown BOP Officer A. Indeed, defendant unknown BOP Officer A engaged in unauthorized access to plaintiff's TrueView records a whopping 153 times. Okay, that's why I had the 100 and something confused. So it was 153 times she accessed the records, but it was only 60 plus people that accessed the records. Okay, so to this day, plaintiff still does not know the extent of his damages, injuries, and loss, as the government has refused to disclose the plaintiff information about the investigation revealed and precise nature of the stolen information. Agent Locke's investigation showed that private and sensitive information from plaintiff's TrueView records became part of defendant Kibi's content in her Instagram posts on January 12, 2020, in videos on November 7, 2019, November 8, 2019, and December 22, 2019. The information included private information about plaintiff's literacy, his medical issues, private information about his romantic relationships. At no point did defendant Kibi reveal the identity of the person who provided her with the information. Indeed, the identity of the individual who revealed the information to defendant Kibi remains a mystery until today. Okay, let's stick a pin here. I really wish she would stop talking about his private relationships. Like, stick to it, may have hampered his defense in the New York case and the Chicago case. Like, stick to those sticking points. But the fact that, him and his girlfriends were bickering because of the release of this information, I think weakens the case. What do you guys think about that? Like, I think she needs to leave that part out. We don't need to hear nothing else about his private relationships. Because technically, if he's on the phone talking to Jocelyn or Azriel or whoever, there are other inmates standing around who could hear those same conversations and go back and share that information. So I think the whole relationship stuff needs to be out of this. Okay, so we're on point 57. It says defendant unknown BOP officer A was not the only BOP officer who engaged in unauthorized access of plaintiff's private records. Agent Lux reported that at least 60 BOP officers had made unauthorized access to plaintiffs' records during a 6-month period. The BOP knows the precise identity of those officers, as do the officers who engaged in the unauthorized conduct. Even after the BOP discovered these rampant violations of the CFAA, they allowed the behavior to continue. The plaintiff learned that in and around August 4th, 2022, an unknown BOP officer made an unauthorized access to his TrueView records and obtained information about plaintiff's inmate funds. That unknown BOP officer leaked information about the balance of funds in his trust account to a journalist for the Washington Post, who published an article with the stolen information provided by the defendant unknown BOP officer. Immediately after the journalist divulged the information, the funds in plaintiff's trust account were confiscated by the United States Attorney's Office. Plaintiff was forced to hire counsel to litigate whether the U.S. Attorney's Office had the right to confiscate, and I think she meant funds, when no restitution judgment had been entered against plaintiff and he was not in arrears for paying any court order fees or costs. Plaintiff promptly filed a notice of claim on November 14, 2022, served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. By letter dated June 15, 2023, plaintiff's claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the plaintiff's counsel. This complaint comes less than 6 months after plaintiff's claim was denied. So now we're in the next section that says causes of action. First cause of action, negligence against the defendant, United States of America. Plaintiff repeats and realleges all of the paragraphs in this complaint as if fully set forth herein. The Federal Bureau of Prisons is a United States federal law enforcement agency within the U.S. Department of Justice that operates U.S. federal prisons and is responsible for the care, custody, and control of prisoners. Defendant, United States of America, owed a duty of care to the plaintiff who was incarcerated in the BOP. The defendant stood in such a relationship with plaintiff that the law imposed on the defendant an obligation of reasonable conduct for the benefit of the plaintiff, including protecting his confidential and sensitive information, including attorney-client communications, and to protect him from exploitation from its employees that could result in harassment and prejudice to his pending criminal cases. Specifically and consistent with his own policies and regulations, defendant United States had a duty to ensure that plaintiff's confidential and sensitive information was accessible to only those BOP officials with a legitimate basis to review it. The BOP had a duty to protect the sensitive information from disclosure and theft to protect both plaintiffs from exploitation by BOP personnel. As set out in detail above, the defendant, United States, breached that duty when it permitted countless BOP officers, including unknown BOP officer A, unlimited access to the information, the ability to download it, and ability to sell and or divulge it, which unknown BOP Officer A did when she provided private information to Defendant Keeby. The breach further caused the publication of confidential information obtained from plaintiff's trust account, which was stolen and shared with other media sources. Even after the BOP became aware that its employees were repeatedly accessing plaintiff's private and sensitive information without legal authority, it took no steps to prevent the misconduct. The breach was the direct and proximate cause of plaintiff's injuries, namely the release and dissemination of his private and confidential information to third parties and the public at large. The public dissemination of private communications, including attorney-client communications, interfered with plaintiff's relationships, led to harassment from the public, and caused serious prejudice to plaintiff's defense. The defendant, United States, knew or should have known that by allowing unfettered access to plaintiff's private information, BOP officers would access, steal, and exploit that information for financial gain or for clout. Plaintiff suffered emotional and psychological distress from the breach, which his sensitive nature was used to harass him, interfere with his personal relationships, and was used to interfere with the defense of his pending cases. Plaintiff also suffered monetary damages, including but not limited to legal fees. Second cause of action, invasion of privacy. Against unknown defendant, Bureau of Prison Officer, also known as Officer A, and other John and Jane Doe BOP officer whose identities have been concealed by the DOJ and BOP, and defendant Keeby. Plaintiff repeats and realleges all of the paragraphs in this complaint as if fully set forth herein. Defendant unknown BOP Officer A and other unknown BOP officers committed repeated unlawful and unauthorized intrusion into plaintiff's confidential and sensitive information. The intrusion is highly offensive and objectionable to a reasonable person, although certain privacy rights are forfeited when an individual is arrested and incarcerated. Plaintiff, who was not yet convicted, still maintained a recognized privacy interest in his communications, visitor list information, trust account information, and his attorney-client communications per the BOP's express policies. This information, set out in detailed fashion above, was defined as private and confidential by the BOP itself. The information was not for public consumption. Plaintiff had every right to trust that his messages with third parties, his phone calls with friends, family, and lawyers would remain under the care of the control of the BOP and not be published to the media for financial gain or in connection with interfering with his right to a fair trial. As reflected above, the communications were private in nature. They related to personal and family problems, romantic interests, health problems, literacy issues, and issues related to the defense of his pending criminal cases. Clearly, plaintiff's conversations with his girlfriend, Jocelyn Savage, were personal and private, as were plaintiff's conversations with his attorneys. Simply put, the information was not public information. The intrusion caused the plaintiff anguish and suffering. The release of his private communications were broadcast to the public. The communications led to the less, you already said this, about the important relationships, blah, blah, blah. The violation even led to plaintiff having to seek psychological care in the MCC for psychological stress caused by this intrusion of privacy. So the third cause of action, conversion, against unknown defendant BOP officer, also known as Officer A, and other John and Jane Doe BOP officers whose identities have been concealed by the DOJ and BOP and defendant Keeby. Plaintiff repeats and re-alleges all the paragraphs in this complaint as fully set forth herein. And basically, defendant unknown BOP officer A made repeated unauthorized access to his information. Says that she stole the information to defendant Kibi. Defendant Kibi used the stolen and private information for financial gain by divulging it to her viewers on YouTube. Basically just repeating what she said above. Fourth cause of action, civil conspiracy, naming the same defendants. Says that he's repeating what he's already said above. As described more fully in the preceding paragraphs, the individual defendant, BOP officers, acting in concert with one another and other co-conspirators, known and unknown, conspired to accomplish an unlawful purpose by unlawful means. In addition, these co-conspirators agreed among themselves to protect one another from liability for depriving plaintiff of his rights. In furtherance of the conspiracy, the defendant, BOP officer, including Officer A, committed overt acts and were otherwise willing participants in joint activity. The violations of Illinois law described in this complaint, including defendant's invasion of privacy and violations of the federal computer fraud and abuse, were accomplished by defendant's conspiracy. The misconduct described in this count was objectively unreasonable, was undertaken intentionally and in total disregard for plaintiff's rights. As a direct and proximate result of this misconduct, plaintiff suffered injuries, including but not limited to emotional distress, as is more fully alleged above. The fifth cause of action, intentional infliction of emotional distress, same defendants. Plaintiff repeats and re-alleges all the paragraphs above. The acts and conduct of the individual defendants as set forth above were extreme and outrageous. The defendants intended to cause or were in reckless disregard of the probability that their conduct would cause severe emotional distress to the plaintiff. The individual defendants' actions and conduct directly and proximately caused severe emotional distress to plaintiff and thereby constituted intentional infliction of emotional distress. The misconduct described in this count was undertaken by malice, willfulness, and reckless indifference to plaintiff's rights. As a direct and proximate result of defendants' wrongful acts, plaintiff suffered injuries, including but not limited to emotional distress, as is more fully alleged above. The sixth cause of action, intentional infliction of emotional distress, same defendants. Plaintiff repeats and re-alleges what he said above. At all times relevant to the complaint, defendant had a duty to refrain from willful and wanton conduct. Notwithstanding that duty, these defendants acted willfully and wantonly through the course of their actions to violate his rights. As directed and proximate result of defendants' wrongful acts, plaintiffs suffered injuries, including but not limited to emotional distress. Seventh cause of action, violation of the computer fraud. Basically say the same thing. Specifically, defendant Officer A accessed TrueView records, a BOP prisoner without authorization. She exceeded her authority by sharing that information. It says the information accessed and retained by defendant A, Officer A, from a BOP computer has been determined by the United States of America to be protected against unauthorized disclosure. Defendant BOP officer sold or transmitted that protected information to a third party who publicly disseminated it. A search warrant application filed by Sergeant Locks shows that probable cause exists to believe that defendant Officer A committed the offense of Title 18 United States Code 1030 A2B. Losses in excess of $5,000 accrued as a result of the CFA violation committed by defendant BOP Officer A. The misconduct resulted in an internal investigation by the BOP, an investigation by the DOJ, OIG. It's like she's pretty much repeating herself. Okay, so wherefore, plaintiff Robert Kelly praised this court enter judgment in his favor and against defendants United States of America, unknown BOP Officer A, unknown John and Jane Doe BOP officers, and Latasha Keeby, awarding compensatory damages, costs, and attorney fees against all defendants and punitive damages against each of the individual defendants in their individual capacities, and for such further additional relief as the court may deem appropriate and just. Jury demand. Plaintiff demands trial by jury. Okay. So what do y'all think? First of all, I love Jennifer Bonjean, but this was really a weak case. I mean, a weak filing. There was nothing surprising in here. There were no aha moments. I think the only new thing that I learned was that the Washington Post story came from a tip from somebody within the BOP who shared how much money he had in his commissary. But Tasha K had already shared how much he had in his commissary, because remember, she told us that Rashona Landfair was donating money to R. Kelly, all the while working with the government and then testifying against him. She was donating money. I think that this is just a move to try and get the information. I'm not sure how any of this worked, because as I told you guys before, when I was earning my college degrees from the University of South Florida, it was not in criminal law. Okay, so Jennifer Bonjean knows better than me how to go about this, but I'm just thinking in my mind, I just would have filed a lawsuit demanding that they turn over the names of the people that were involved. But it looks like she's going this route, because if they are awarded a jury trial, then you have the discovery phase. And during the discovery phase, she will learn who all of these people are. And then I am assuming that there will be other lawsuits and other steps that she will take in order to pursue this further. But going back to the original issue of sharing his confidential information, like I said earlier, it has happened numerous times before. The highest penalty for a employee of Officer A's nature of divulging this information, stealing the information and divulging it to Tasha K, is a misdemeanor. So this lady is not going to jail. She's not doing any jail time. And then there can be a fine. And I think that the monetary fine wasn't that big either. In cases where it did end up going to court, the burden of proof, and it even says it in the documentation, that the burden of proof that a person had, that the plaintiff has to overcome in order to even get recognized in these cases, the burden of proof is so high that most people can't obtain it. Okay, you can't just say they stole my information. It's more than that. You have to show how it actually harmed the person. The harm that was caused to R. Kelly, yeah, it was embarrassing. Yeah, people got his information. Yeah, people stopped writing to him or stopped putting money on his books because they didn't want it to get out to the public that they were supporting him. Yeah, those are horrible things to happen. But did they really damage him? Did it really cause him damage in the terms of he suffered a magnificent loss? And so people can say, well, he did suffer a loss because they took his money out of his commissary. They were going to take that money anyway. Once the restitution was entered, they have the right to go and take that money. Now, in most cases, they don't take all the money at once. They take like 15% of it. But in this case, they were being nasty and they took all the money from him. So maybe that, but even that is such a low threshold. I don't know where this is going. I'm just going to believe that she's doing this to try and get more information to find out if these people actually profited monetarily from this. And the reason I don't think it's really going to go anywhere is because according to the Matlocks' investigation, they were unable to prove that Tasha K had contacted this BOP officer and asked for this information. It seemed as though the BOP officer gave the money because she was a fan of Tasha K. She watched Tasha K's show. And then the FBI has all the access in the world to find out how money is flowing, how we're transferring money. Even if you go to Amscot, like people said to me before, well, you could buy a money order. Who's ever bought a money? If I go to my bank and buy a money order, guess what? That money's coming out of my bank account, okay? And even if I walk into the bank with the cash in my hand, they're still going to connect that money order to my bank account, okay? If I go into Amscot or any of these other check cashing places to buy a money order, these people be asking for ID, all your information. So it is just so easy to trace money. Like they can trace, okay, say it was $10,000 that Tasha K allegedly paid the lady, which we know she didn't. Don't you think they can connect that Tasha K withdrew $10,000 from her bank on this day and then suddenly Officer A deposited $10,000 in her bank account a day or two later? You know what I'm saying? Like they literally would have had to have cash on hand to hand off cash for nobody to know that this transaction took place. And so it would be important to Jennifer Bonjean to be able to get all the details of the investigation to see how far the federal agent went into investigating any financial transfers. Or did they just basically ask Officer A and then ask Tasha K and they both said, no, there was no money, we didn't know each other, and they left it at that? Or did they go even further to see if they can figure out how this money was transferred? You know, did they use other people involved? So say Officer A, who I really, if my memory is serving me correctly, is not in Chicago. She's like in Minnesota, Indiana, or somewhere else, child. Like, does she know somebody who's connected to Tasha K? You know, it's like they would have to be able to connect the dots to prove that Officer A received money from Tasha K in exchange for this. And the protection that Tasha K has is going to come up under journalism. Whereas if somebody, whether the information was gained legally or illegally, if that person gives you the information of their own free will, they're not selling the information to you, then Tasha K receiving that information and sharing that information did absolutely nothing illegal. Like there are reporters who have sat in jail because they refused to reveal who their confidential informant was, who gave them the information. And in the end, those attorneys won because judges ruled that they were under no obligation to share that information. So anyway, it is going to be very interesting to see how this turns out. You guys go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.